So today we're going to talk about Section 504, and if you were here yesterday morning, I had an hour and a half on my presentation. Today I have an hour and I have more slides than yesterday, so we'll have to move quickly through this. In talking about Section 504, it's Section 504 of the Rehabilitation Act of 1973. You also have to consider the Americans with Disabilities Act that was passed in 1990, as well as the Americans with Disabilities Amendments Act that was passed in 2008 that became effective in 2009. So the Rehabilitation Act of 1973 was the first civil rights law that specifically addressed disabilities. Okay, you had other laws that addressed race or gender, but not disability. And it prohibits discrimination on the basis of disability in programs or activities that receive federal financial assistance. So sometimes it's not going to apply to some public or non-public schools, but it will apply to all public schools. Okay. I put in here also, just so you can see in context of time, when this was Public Law 94-142, back at the time that it was passed and probably up and through the mid-1990s, we referred to Public Law 94-142, Congress's definitive response to the growing concern that children with disabilities were not being educated at all or were not being provided appropriate education. This was the Education for All Handicapped Children Act, the predecessor of what we now have as the Individuals with Disabilities Education Act. Okay, then in 1990 is when the Americans with Disabilities Act was passed, and schools probably didn't have to pay a whole lot of attention to the ADA because it did not really provide anything different than what you already had in Section 504. What it did was extend these provisions to places of employment, to places of public transportation and accommodation. So it went a little bit beyond what we had with just in Section 504, just programs or activities that receive federal financial assistance. But you do have to look at the language that is used. Okay, so basically what you have in Section 504, and I'm sorry, when I talk about, when we get to talking about the regulations haven't been amended for many years, and they still talk about handicapped individuals. But the statute has been amended, and it talks about individuals with disabilities. So no qualified individual with a disability shall solely by reason of his or her disability be excluded from participation in, be denied the benefits of, or be subjected to discrimination on the basis of disability. Again, this applies only to programs or activities that receive federal financial assistance. Program or activity includes every program or activity of the entity, the agency, the organization. And this came about from an amendment where Section B was added because of a case of that reached the the U.S. Supreme Court of Grove City College versus Bell, where the college, private college, was accused of discriminating on the basis of disability. The college's defense was, we don't receive any federal funding, but they did accept grant money that students got, or scholarship money that came from a federal source. So the law got changed to clearly identify that the decision, and that was like only the financial aid office of the university or of the college benefited, not the science department where the student was alleging discrimination. So when we talk about the federal regulations, these are the regulations. CFR is Code of Federal Regulations. Title 34 applies to the regulations of the U.S. Department of Education. So anything that's 34 CFR is U.S. Department of Education. Part 104 is where you will find the U.S. Department of Education's regulations pertaining to Section 504. These regulations apply only to programs or activities that receive financial assistance from the U.S. Department of Education. So this is why sometimes you hear that OCR will not enforce Section 504 complaints or Section 504 against non-public schools. In particular, the Archdiocese will say 504 doesn't apply to us. We don't do 504 plans because we don't receive money from the U.S. Department of Education. However, it's going to apply to all public schools in Indiana. So, talk about a handicapped person or a person with a disability, a person who has a physical or mental impairment that substantially limits one or more major life activities. It's only the first one of those that you're going to be concerned about as far as when you have to actually develop a 504 plan. However, you also cannot discriminate against a person who has a record of such an impairment or is regarded as having such an impairment. Sometimes, you know, people have looked at someone and thought they look a little different, they must have a disability. You can't treat them that way or discriminate against them because you think they might have something or they've been regarded or treated that way. Okay, look at the definition of what does that physical or mental impairment mean. And you see, understand this is a non-exhaustive list. Any physiological disorder or condition, I'm not going to read through all of these because you've got it there in your materials, or any mental or psychological disorder, such as, okay, these things say such as, it's non-exhaustive. And we're going to see that some of these things get expanded with the ADEA amendments. Okay, handicapped person. The next definition we're going to look at is what is the major life activity. Under Section 504, we had functions such as, and again, this is a non-exhaustive list, caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. For a number of years, schools would look at a student and in determining whether the student was eligible for services under Section 504, only focused on the learning. You know, there are other things here too. It's not just learning. The student's disability does not have to necessarily affect learning for the student to need accommodations under Section 504. I went to school with a girl, okay, now I'm really giving you my age here because all of my going to public school was before any of these laws were passed. But our school did make some limited accommodations for her because she had difficulty walking. She had polio, she then had legs, braces on her legs and used crutches to walk. 1 year well, the elementary school we attended was about 3 blocks away. Then when we went to junior high and high school, that was 3 blocks in a different direction, but still only about 3 or 4 blocks away. There was 1 year when they were remodeling the elementary school that we had gone to, and we had to go to a different elementary school that was just under a mile from our house. And our school's policy was if you lived more than a mile away from school, you could ride the bus. If it was less than a mile, you could not. You had to walk. That 1 year, they did let her ride the bus. And because they were going to come to pick her, she still had to walk a block to get to the bus pickup. They didn't come door to door. But that 1 year, they let her brother, she was a year older than me, they let her brother who was my age and me and another neighbor girl also ride the bus. So that was kind of awesome. We got to ride instead of having to walk. And then when we were in junior high and high school, the building was only 2 stories. Kids, of course, couldn't use the elevator, but they did let her use the elevator. So those are the only 2 accommodations I'm aware of that they made for her. Other kids carried her books for her. So you just did what you had to do to enable the student to participate fully. But her disability did not affect her ability to learn, but it did affect her mobility. Okay. Qualified handicapped person is another word that you need to know. What does that mean? When you look at in employment law, Qualified means that with or without accommodations, that the person can perform the essential functions of the job. We don't get to do that in education and say, oh, well, with or without accommodations, can the student perform and learn? No. You take all these kids, qualified here just means they are of an age when non-disabled students get to go to school. Okay, so it's going to include compulsory school attendance age, beginning with the school year when a student turns 7 until age 18 or until they receive a high school diploma. It's also going to include the ages when other students with disabilities under the IDEA in Article 7 are entitled to receive educational services, which begins on the student's 3rd birthday and ends at the end of the school year when the student turns 22. So any students with disabilities within those age ranges, if they haven't yet received a high school diploma, they're going to be qualified individuals with disabilities. Okay, general prohibition against discrimination. Again, definitions. You can't deny them the opportunity to participate in any program or activity or afford them opportunities that are different unless it's required by the nature of their disability. Okay, it doesn't do any good to provide an aid or benefit that's not being effective. And again, separate aids or benefits only if that's required by their disability. There is not a requirement or a guarantee of any particular outcome, but you need to make the opportunities available. Okay, schools, well, any entity here under Section 504 that receives federal financial assistance from the U.S. Department of Education, you have to designate a responsible employee, the agency rep, somebody who is going to be responsible to make sure that Section 504 is implemented. Sometimes this is the special ed director, sometimes it's the principal, sometimes it's a counselor or a social worker. That's up to you, but you need to make sure the person knows what they're doing and understands the requirements of Section 504. You need to have grievance procedures. Okay, you will find that the 504 regulations encompass almost all of the same procedural requirements that we have under the IDEA in Article 7. However, the details are not there. They make the requirement that public agencies do this, and they make you responsible for having those procedures and policies that follow the law. The regulations oftentimes make a referral and say, compliance with IDEA will meet these requirements. So your procedures should be something similar to that. Okay, again, this particular subpart, when we go through sections 104.31 through 104.39, applies to preschool, elementary, and secondary education. There are some other regulations that appear after that I'm not going to talk about at all that apply to post-secondary education institutions. So that's beyond the scope of our talk here today. Location and notification. Okay, under IDEA, you have child find responsibilities. You also have child find responsibilities under Section 504, that you locate and identify all students with disabilities that are in your school, for charter schools. Okay, public school corporations also have to locate and identify all students with disabilities that reside within their boundaries or that attend non-public schools that are located within their boundaries, regardless of where the student lives. So public school corporations' child find responsibilities are somewhat broader than yours, but you are responsible for locating, identifying, and evaluating all students with disabilities that are attending your school. Just like under IDEA, students are entitled to a free, appropriate public education, and they mean pretty much the same thing. Okay, appropriate. You have to provide appropriate education that is regular or special education and related aids and services that are designed to meet the individual needs of the student. Okay, what this is considering leveling the playing field. You have to meet their needs as adequately as you are meeting the needs of students without disabilities. And you're supposed to follow the procedures that are set forth that we're going to talk about in sections 104.34, 35, and 36. Some of these students only need accommodations. They don't need specially designed instruction, but 504 does encompass both. But oftentimes we're talking about accommodations. And we're talking about here students that are not eligible under the IDEA, okay? Although all students that are eligible under IDEA are also eligible under Section 504. But if you're addressing their needs through an IEP, in that process, you don't have to do this procedure as well. Okay, free appropriate public education. Appropriate means you're going to implement an IEP. If you do that in accordance with the Education and the Handicapped Act, or now Individuals with Disabilities Education Act, that's one way of meeting these needs, but you're only going to do the IEP if the student is eligible under Section 504. Free education. Okay, this is one of the things that always kind of makes me think back to Bill Clinton's comment about it depends on what the definition of is. That free doesn't always mean free without cost at all, because you can charge the same fees that you might charge to a student without a disability. In Indiana, we still have book rental. A lot of states don't, but so you can still charge that. Transportation at no greater cost than incurred by non-disabled students. Mostly we don't charge for transportation, but if a school did, if you charge lab fees for a science class or something like that to non-disabled kids, you can charge those same fees to a student with a disability. Okay. There's an OCR finding back in 2006 that said the same thing, that Section 504 does not require districts to pay fees that are imposed on non-disabled persons or their parents or guardians. But you do have to do evaluations without, charge. Okay, academic setting. Again, the academic setting should be the same as those students without disabilities. Okay, you would only remove the student from a general education setting if it's necessary based upon that individual's needs, and even with the use of supplementary aids and services, that satisfactory achievement can't be achieved. This applies in non-academic settings as well. If you have extracurricular clubs or sports or activities, I guess that's the next one. Actually, here talking about meals, recess, physical education, some that are not the traditional educational academic settings, that you still have to include students with disabilities, again, unless it's not satisfactory based upon the individual needs of the student. In comparable facilities, I don't see this very much anymore, but a number of years ago, you would occasionally see some schools that had portables because they were overcrowded or whatever, and they'd bring in these extra buildings. We had some at one of the elementary schools I went to as a kid. But there were some situations where schools would do that, and oh, well, the special ed kids are all out in the portables and everybody else is here. No, you can't do that. Those facilities are not comparable to what you are providing for non-disabled students. Okay, so evaluation and placement, just like you have under the Individuals with Disabilities Education Act in Article 7, you have to evaluate students who are believed that they might have a disability, and again, you need to have written parental consent before you can evaluate. Your evaluation procedures need to make sure that they are appropriate for what you are evaluating and that you are not going to get depressed results because of the disability. They have to be administered by people who are trained to do so. You need to make sure that your evaluations assess the areas of suspected disability and should not just be based upon a standard IQ test. And we need to make sure that they accurately reflect the student's abilities or aptitude or achievement and are not going to be depressed based upon the person's depressed skills, unless those are the skills you are actually testing at that time. Okay, so when you make the determination about students being eligible. You're going to be doing a similar type of thing to what you do with under the Individuals with Disabilities Education Act. You should be drawing information from a variety of sources, getting parent input. If parents have any test results or anything, the test results you just did, get information from teachers. Typically you're going to do a social background or something like that, and look at all the information you have about the student to determine whether the student might be eligible for services under Section 504. Okay, documentation. Again, everything we're doing with students with disabilities, schools really need to document it. That's your way of showing compliance later on. Since that's the area I deal with is in compliance, you know, we sit there and say, document, document, document. Okay, I will sit there and say, we don't enforce Section 504. That goes to the U.S. Department of Education's Office for Civil Rights. And the Chicago office is the one that has jurisdiction over Indiana. So we'll try to answer 504 questions if we can. However, OCR is the one that has the authority there, not us. Ensure that decisions are made by a group of persons knowledgeable about the student. Okay, Section 504, unlike IDEA, does not specify all the people that need to be participating in that to make that eligibility determination, or to make a placement determination, or determine what services should be provided. And it specifically does not include the parent, but it doesn't exclude the parent either. And I will tell you, you should always make sure the parent is there at the table with you to make all these decisions. Okay, that's probably one of the biggest things you'll get hit with in the complaint, is that you did these things without consulting with the parent. I would say it depends. The question here is, if we have medical documentation, does that meet the criteria? The regulations talk about drawing information from a variety of sources. I would think you need to look at it. It depends, I would think, on what the suspected disability is. And parents oftentimes will come to the school with medical documentation. They'll sit there and show you that the student has been diagnosed with, you know, XYZ, whatever, and this is what the doctor says that the student needs. But look at that, talk to the teachers, you know, meet with the parent. Do we need additional information? And if so, then do those evaluations. If not, go ahead and convene your meeting. If it's medical information, I would suggest you make sure you have a nurse, your school nurse, at that case conference meeting, or whatever you want to call it, your 504 team meeting or whatever, and discuss what these needs are. Sometimes we're talking about only having to provide some sort of medical accommodations in that a student with diabetes, for example, okay? That's typically going to be a situation where the parent brings you that information and says, my student has diabetes, needs to test blood sugar level, needs to have access to food or snacks at certain times, or is insulin dependent, or whatever it is. Most of the time you're going to have those discussions with your school nurse, but somebody else at the school should be involved with that as well, because maybe it involves the student needs to be able to, you know, leave class at certain times to go to the nurse's office for testing. Sometimes your teachers need to be aware, to be observant, to notice that this particular student seems to be acting weird, that the blood sugar level is too low or too high, and so maybe your staff needs to be aware of times when they need to suggest that the student go to the nurse, or the student maybe needs to be escorted to the nurse, or the nurse brought to the student, depending upon those conditions. So, you know, diabetes is one instance where probably that medical documentation is going to be the main thing that you need, okay? But remember, it is the school's responsibility to conduct evaluations, and that could even include a medical evaluation, that, you know, you need to have a physician examine a student to determine certain things. If a parent comes to you and says, my student has such and such, or I suspect this, and need accommodations, and you think you need evaluation material, that's on you to get it done, okay? So, too often schools just tell the parent, well, you need to go to the doctor and get this information and bring it back to us before we can provide accommodations. If the parent doesn't already have that, that's on you. Not many schools do that, you know, I mean, but it really is on you to get that evaluation done, and should be at no cost to the parent. Okay, again, placement decisions made by a group of people knowledgeable about the students, and you also have an LRE requirement that the placement should be in the least restrictive environment appropriate to meet the needs of the student. Reevaluations are also provided for here. IDEA in Article 7 will sit there and say you should reevaluate every 3 years unless the case conference determines that that's not necessary, or unless a parent or the school request an additional evaluation or reevaluation more frequently. Section 504 does not put timelines in there, but does say periodic. Something similar to what you do under IDEA would be appropriate here. So when you write your policies or go back and review your policies, make sure that they provide for reevaluation. Suggesting every 3 years unless more frequently is required or determined necessary would be a good idea. But make sure it's in there and make sure parents are aware of that. Procedural safeguards. Just like under IDEA, you should have procedural safeguards. Parents should have access to students' records. Parents should understand that they have the right to file a complaint with you or with OCR. Parents have the right to request a hearing. And that hearing request goes to you, not to us, because it's not an IDEA hearing, it's a 504 hearing. And you need to have hearing procedures. And it's a local hearing, but it cannot be one of your employees, okay? You would have to have arrangements with somebody other than one of your school employees to be the hearing officer. Parents would have the right to be represented by counsel or by somebody else knowledgeable, and there should be some sort of review procedure. So your procedural safeguards, again, compliance with something similar with IDEA will meet the requirements. Okay, in non-academic services, you need to provide your non-academic and athletic services should be equally available to students with disabilities as well as non-disabled students. They should be able to participate similarly. You need to do things to level the playing field. Okay, your non-academic services might include such things as counseling, physical education, recreational activities, transportation, health services, anything that you are sponsoring, special clubs or interest groups. Make sure that students with disabilities can equally participate. One of the things you need to look at, both for kids under IDEA and Section 504, is that if they need accommodations in the classroom, they might also need those accommodations in those extracurricular activities. Okay, and that's something that you should be looking at providing so that they can fully participate. Counseling services. One of the things that I guess I hadn't really thought about too much until I would read these is that your guidance counselor should not be making assumptions as well about the limitations that might be placed on a person with a disability. Should not be counseling students with disabilities towards not as challenging post-secondary activities or career objectives by making some assumptions about what a student can't do. Certainly you want to be realistic, but that should be done in the case conference. But don't make assumptions that, oh, well, you've got a disability. You're probably not going on to college, so you should go this route instead. So make sure that everything you're doing is going to be in a non-discriminatory manner. Physical education and athletics. Shouldn't be offering things that are separate or different. Students with disabilities should be able to fully participate, unless, of course, the nature of their disability actually prevents that, and you don't offer separate or channel them into separate activities unless it's necessary based upon their disability. Okay, preschool and adult programs, if you offer either of these, again, Section 504 would apply, and you would have to meet the needs of individuals with disabilities as equally as you are meeting the needs of people who are not disabled. Private schools, if they receive federal funding from the U.S. Department of Education, then these regulations apply to them to a more limited extent. They cannot discriminate on the basis of disability or exclude an individual with a disability if they can, with minor adjustments, provide an appropriate education within their system. So that's different than public schools. Public schools, you can't exclude any student, regardless of the nature of the disability or how major the adjustments might be that you have to do. Again, in private school, it says they can't charge more unless they incur a substantial cost. So if they would have a great cost in providing some additional services, they could charge those parents something more. Public schools cannot do that. They have to also comply with these same procedures that are set forth in sections 104.34 through 104.38. Okay? The extent of that's going to be more limited. So what happened with the Americans with Disabilities Amendments Act? Don't you just love the acronym up there, ADEA? It expanded the list of major life activities that are included in the ADA's definition. And we talked about that in Section 504 definition of what is major life activities. So it greatly expanded that list. It also went on to say that you cannot, in making that eligibility determination, you cannot consider the mitigating effects of, I'm going to say mitigating measures, to determine whether or not a disability is substantially limiting. So it used to be, oftentimes, that schools might sit there and say, well, yes, the student might have been diagnosed with ADHD, but the doctor prescribed medication, and as long as the student is taking medication, his behavior is controlled, and his concentration is better, he's able to focus, so we don't need to do anything. What the ADEA says, you don't consider that. You look at how the student would be if the student was not on medication. If he would be eligible then he's eligible. A student who is bipolar, and as long as they're taking their medication, their behavior is controlled and everything's fine, so schools would sometimes say, well, you're not eligible. This can be controlled with medication. ADEA says, no, you look at how the student would be if they weren't on medication. So these individuals would then be determined eligible. It also provides that if there's some impairment that is episodic, you have to look at how that impairment would affect the student when it was active. An example might be a student who has been diagnosed with cancer. Okay? They're undergoing chemotherapy, they're tired, they're lethargic, they can't always concentrate or come to school or whatever. Oh, but now the cancer's in remission. They're still going to be considered eligible because when it was active, they would be covered. And it would be if it was substantially limiting. So the term disability, this is still pretty much the same. A physical or mental impairment that substantially limits one or more major life activities. Major life activities. Okay, this list has expanded. Okay, the list that we had before talked about caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Now you see that the list of major life activities is larger, okay? More things to look at, and again, it's not exhaustive, but they actually put more things in here. Okay, major bodily functions. The list of major life activities now, not only did they add more in subpart A, but they also included major bodily functions as being a major life activity. So one of the things, a good example here is affects the endocrine system. This is included both as a impairment as well as a major life activity. So using that as an example, a student with diabetes is going to be eligible because they have a major they have a physical or mental disability that affects the endocrine system, and then it affects the major life activity because it affects the endocrine system. So you get it both ways there. So you look at all of this, that we have a lot of more students that under the ADEA are going to be considered eligible than what we had before. Okay, again, regarded as we used to often say, you know, something that's short-term, transitory, it's not going to last very long, it's just a temporary thing. A general rule of thumb is 6 months. If this is a short-term, within 6 months that everything's going to be better, then probably not eligible under Section 504. However, I would still say you need to accommodate whatever the student needs, you know? Okay, I broke my leg. I can't walk up downstairs now. I'm on crutches or whatever. It's not going to last more than 6 months. I'll be off of crutches and be able to walk again, but schools are still going to accommodate that. Yes?
What about pregnancy?
I don't think pregnancy is considered a disability, but I would still say you should accommodate the needs of the pregnant girl. Okay? Some schools, you know, schools handle all differently. Some schools are still in a mindset of not wanting girls that are pregnant coming to school. You know, back in my day, they tended to go someplace else and have that baby, you know. But certainly there's going to be a period of time when they're not going to be able to come to school, and that's going to vary depending upon the nature of how the pregnancy is affecting the person. But again, any period of incapacity during that time is probably going to be 6 months or less, but it might not be. I think you need to look at that on an individual basis, but I would certainly encourage you to make whatever accommodations you need to make for that girl to make sure she can continue her education. Because dropping out of school and being a single parent and not finishing your high school education is not going to help either that girl or her baby.
We're virtual.
Well, virtual school, then, you know, yeah, you have fewer problems that way as far as...
That's why it's like, you do it. Right.
So, what does she need? Does she need anything, you know?
Several.
What do they need? All right. Yeah, so make it plural.
And so that's just like some of them want attendance accommodations, some of them want some other accommodations. And sometimes they just need it for state testing and then only during this pregnancy. But
okay, when you're talking about accommodation on state testing, though, you have to be real careful about this because you're not supposed to be getting accommodations on state testing that you don't require during your other coursework. Okay, so, you know, that's kind of a requirement for state testing, for SATs, PSATs, all that kind of stuff, whether it's iStep and iLearn or wherever we're going with you know, the state testing. Accommodations that are provided on those state and district-wide types of testing should be the same thing that the student requires in their everyday coursework or testing for, you know, particular, you know, classes. Okay, the ADEA also included additional language to say, considering the disability, they want this language to be construed broadly in favor of more people being found eligible. That they don't want to say substantially limits doesn't mean that it prohibits entirely or that it significantly limits. An impairment, again, that is episodic or in remission is a disability if it would substantially limit a major life activity when it was active. And being a substantial limitation on one activity doesn't mean it has to affect other major life activities. And again, that major life activity that it affects or limits or impairs does not have to be learning. And the determination that you make is without regard as to whether the student is taking their medication, other medical supplies, equipments, appliances, prosthetics, anything else like that. You cannot consider the effects that those accommodations have. Again, or use of assistive technology. Learned behaviors. Sometimes a student has learned how to accommodate their own needs, but you have to look kind of beyond that. Without that intervention, without those accommodations that are being provided, does the student have a disability that would be a substantial limitation on a major life activity? Okay, the OCR issued a Dear Colleague letter back in 2012 that responded to some of these things, and this kind of goes over it was done in a form of a question and answer, so I put a few of them in here, but it kind of reiterates some of the language that we just talked about. So what did the ADEA do? It made the coverage much broader. They've indicated that, even if you looked at a kid before those amendments under Section 504, you might need to reevaluate. Now, we're going back a lot of years, okay? Those amendments came out in 2008, and yet a lot of people weren't doing this. And this Dear Colleague letter came out in 2012, so even at that, we're talking about that was 5 years ago. So we should really be using those definitions that came out of the ADEA and not going back to just what's under Section 504 or the ADA. An impairment need not prevent or severely or significantly restrict a major life activity to be considered substantially limiting. Without regard to, again, mitigating factors or whether it's episodic or in remission, look at when it would be active. Should we revise our policies if we haven't updated them since the ADEA? Yes, make sure that you do that and that you are in compliance with what the standards are now. So yes, we've expanded significantly the list of major life activities. And no, learning's not the only major life activity. Okay, that's one of the big things I think when we look at under IDEA, we look at whether a student has a disability. We have a listing of 13 disability categories under IDEA in Article 7, but not only does the student have to have one of these disabilities, but as a result of that, they require special education and related services to be able to access their education, okay? Under that, we are really focusing more on the student's ability to learn, the student's ability to perform in school. Under Section 504, we're looking at the student's ability to access a wide variety of life activities. So these are some things that are quite likely to be eligible under Section 504. That may or may not also be eligible under the IDEA. And if they are under the IDEA, they're probably going to fall under the category of other health impairment. But other health impairment, you need to, again, look at the definition under Article 7 IDEA, and it talks about the student is lethargic or not alert or whatever. Sometimes these things kind of go the other way. But do make sure that students with these types of needs are being accommodated in your school. Okay, this diagram is not at all meant to be to any sort of scale. It's just a picture I was able to draw. Since I can't do a whole lot with the drawing tools and whatever that are available on the computer. But what I want to get across to you is that every student who is eligible under Section 504 is not necessarily eligible under the IDEA, but the other is true. A student who is eligible under the IDEA and Article 7 is also encompassed under the broader protections of Section 504. Okay? It's kind of a subset of eligible students under Section 504, but you don't have to do both, okay? So one of these frequently asked questions the OCR responded to is, if a student is eligible for services under both, do we have to have an IEP and a 504 plan? No, you don't. Anything that the student needs, you can address in that IEP. Okay, we even have one of the subsections in Article 7 does say that the IEP should address all of the student's needs in education, not just those related to the particular identified disability. So there are some schools that do both a 504 plan and an IEP, and there are some school attorneys out there that will tell you to do both. Okay, it's not necessary. That's going to be up to you how you want to do it. And one area where they might not, for example, is in diabetes. For a student with diabetes who might also have another disability, okay, Indiana has a law very specific to students with diabetes about creating the health plan that the parent brings in from the treating physician or the health care provider, the student's needs to address the diabetes, and then the parent takes that to the school nurse and principal, sit down with the parent and develop a health plan to be implemented in the school. And sometimes if that's all the kid needs, you know, that's probably enough, but you need to make sure that the student doesn't need anything else. Because I will sit there and tell you, and the American Diabetes Association would say, the student's eligible under Section 504, so you need to convene a bigger meeting and say, are there other accommodations that the student also needs besides just testing the blood sugar level and making sure that the student gets access to snacks and insulin when necessary? That there might be at times where if the diabetes has affected the student because of low blood sugar or high blood sugar while the student is taking a test or something, does the student get the opportunity to retake that test or get extra time or something like that? If the student has to leave the classroom in the middle of an assignment or in the middle of testing to go to the nurse's office, how are we accommodating that? So those things might need a broader 504 plan and should be addressed that way. So all those things could be incorporated into your 504 plan. If the student's also eligible for, under IDEA section and Article 7, you can incorporate all that into an IEP. Sometimes you might have a piece of that where you sit there and say, you know, some of the medical needs, though, really just need to be kept in the nurse's office, that every teacher who's touching this kid doesn't need to see all the medical diagnosis and all that. So you might make reference in the IEP or in the 504 plan to the health plan that is maintained in the nurse's office. And there are different levels of confidentiality that you might be looking at based upon a student's particular needs. So we got through that. Any questions?